The Center for Continuing Education, CCE, is a State Bar of California MCLE approved provider. CCE certifies that this program is approved for 1 hour of MCLE credit. CCE, the Center for Continuing Education presents Patent Fundamentals for Non-Patent Attorneys, presented by Stephen A. Nielsen of Larkspur, California.
Steve Nielsen is a founding partner of Allman & Nielsen based in Marin County, California. Mr. Nielsen is a U.S. registered patent attorney with many years of experience in obtaining patents and achieving favorable results in federal court in the field of intellectual property litigation. He is the current chairperson of the intellectual property section of the Marin County Bar Association. Mr. Nielsen received his J.D. in 1987 from Bolt Hall, University of California at Berkeley, and also holds a B.A. in computer science.
Good afternoon. Thank you all for coming here. I hope to put on a interesting and informative presentation on patent fundamentals for people who are not registered patent attorneys. My goal is to convey 5 concepts to you. What is a patent? What might be patentable in 2010? What are the important deadlines that you might want to be able to convey to your clients so you don't blow any statutes of limitation? There's just a couple deadlines you need to know so when a client comes in, you don't do anything to harm their interests. Then I want to talk about what patent work can you perform even though you're not a registered patent attorney. Then conversely, what patent work or patent punishment, as I call it, is reserved for registered patent attorneys. First of all, what is a patent? A patent, if you're lucky enough to get one, looks like this. It's issued by the United States government. Thomas Jefferson was our first patent examiner and patent commissioner. And so it's issued by the United States of America. It comes from an organization called the United States Patent and Trademark Office. And what this is, it's a right to exclude others from manufacturing, importing, or selling items within the United States. It's not a right to make things, it's a right to exclude others. And it excludes things such as a product, a machine, a composition of matter, a plant, a design, a machine, anything that's, quote, covered by the patent. Now, the next important issue to understand is what is covered by the patent. What's covered by the patent are the contents of the claims, and in a patent, the claims are always found at the very end of the document. So you have this right to exclude others. Sometimes many good patents are for compositions of drugs or new treatments, so you may need FDA approval, or sometimes a patent is an improvement upon an existing product, and if the existing product is still in its patent, the inventor may need to get a license to practice his invention. Patents in this country are good for 20 years from the filing date, which is in parity with other countries, as our patent office tries to be in line with other countries so that we have a more unified system throughout the world. So if your client is lucky enough to have a patent, he or she can stop imports from people bringing the covered product into this country, and they can stop the domestic manufacture or sale of products covered by the patent. So there is no international patent. If you want a patent in Germany, you have to go to Germany, file, and you get some document. It looks like this. So each country has their own patent office. Each country wants to get their fees, and each country has their own unique quirks about granting patents. So people come in, they want an international patent. There's no such thing as that. Sometimes a client will come in and they'll have a gadget or an invention, and they'll go on Google and they'll look for some patents, and they'll find a picture just like it, and they'll say, oh, am I going to get sued for making this? Well, you need to tell your clients that The patent only excludes what's covered again in the claims. The claims are found at the end of the document, so don't be discouraged if a picture of the product is in an existing patent or described in general. Again, it's just the claims that your client needs to worry about if they're worried about infringing on a product. And what's interesting with Google Patents, clients can do their own searches and they find a lot of interesting things, and they have a lot of interesting questions to go through about the various products that they may have invented or that they want to invent. So number 2, what might be patentable in 2010? Various clients will come into your office and they'll show you a gadget and they'll ask, is this patentable? And probably your best answer, if you're not a registered patent attorney, is to say, go ask a registered patent attorney. It's hard to say unless you're doing this day in and day out because the law changes. But if they press you, you may want to give them some general guidelines so you don't get their hopes up too high. Generally, in the last 5-10 years, patents are more difficult to obtain than they were in the past. There's sort of a public outcry about excluding others from inventions that might be considered obvious. And some people find patents to have an anti-competitive effect. Other people really believe, as I do, that patents help reward innovation. People spend money in R&D and they get the patent and they profit from it, and then they have more money to reinvest. But we're not going to solve that issue here. But the trend is things are more difficult to patent now than they were in the past. So the first 3 considerations you may want to tell your client about is that a invention, process, material has to be new. So that has 2 different types of meanings. One is your client cannot have offered it for sale or used it in public for more than 1 year before your initial patent filing. And we'll talk about that more in the deadline section. So it has to be new. They can't be using it for 5 years and then file for a patent. Then the item has to work or be useful. It doesn't have to work perfectly, but it has to have utility. And there are plant patents, utility patents, and design patents. And by utility, it has to have some value to it. Now, fortunately, the threshold is very low. There was a famous case involving some semiconductors that didn't work. And during the prosecution of the patent attorney said, well, the utility is it can be used for landfill. You can fill things up with it. And the patent office said, no, that's too low. It has to be better than landfill. But the standard isn't much better than landfill. So it has to have some utility. It doesn't have to work perfectly. Then here's what we're going to spend some time discussing. The methodology of the invention has to be unobvious. In other words, if someone were to come in and say, I have a pencil with an eraser on top, the patent office would say, well, that's an obvious combination of known components. One skilled in the art would have thought about putting an eraser on top of a pencil and calling that a product. So what your client needs to do is think about how their invention is not obvious to one reasonably skilled in the art. And the big case on this is called KSR versus Teleflex. That case involved a sensor on a gas pedal, electronic sensor on a gas pedal. The gas pedal would be pushed down. It would send a control signal to the carburetor or fuel injection, open it up through the sensor. So we know about sensors, we know about pedals. Somebody got a patent for that. It went to court, and the court said, no, that's an obvious combination of known components. We're not going to uphold a patent for a gas pedal on a sensor. So the case law is in a state of flux, and the next couple of years we're going to get a more definitive answer as to what is obvious and what isn't. The guidelines are, if one reasonably skilled in the art would consider trying this particular invention, and a good example is if you have a 5-spoked wheel system to make 6 spokes, that would be considered obvious. Someone skilled in the art would consider doing experimentation or adding another element. The other thing interesting about patents is that There can be a patent for an object. Say there's a patent, the design patent on this hair clip made in South Africa, and if someone were to come by and scale this up or make it smaller, the patent on this product would still hold. So people ask me that, can I make if somebody makes it bigger or smaller, can I still sue them for infringement with my patent? And the answer is yes. So that's, people will ask you, can you adjust things a little bit? And with a design patent, we have the ordinary observer test, meaning if one looks at it, this product and a knockoff, if they see a substantial similarity, you're going to get to sue them for patent infringement. And that's another thing that as a non-patent attorney you can do in federal court. And there's a lot of great patent litigators who are not registered patent attorneys, and they have very, very good careers doing that. The other issue or test for obviousness is, would one find the proportions of the materials or measurements by regular experimentation? So if you have a composition of some salt, some sugar, some water, some caramel, maybe you have Coca-Cola or Pepsi there, and if you were to change those proportions to have a different flavor or something, the patent office would say, well, that's within normal experimentation and we're not going to issue a patent for that. So in the slide here we show somebody mixing some chemicals, and then we show somebody measuring things, trying to find different lengths of an element. Okay. The other thing that comes up quite often is people say, well, gee, I have hair clips or some item. What if I make them out of aluminum? What if I make this out of bamboo, carbon fiber, Kevlar? Can I get a patent for that? And generally the answer is no. And that the patent office has held that changes to the material of an object are an obvious deviation, especially if you achieve expected results by the change in the material. And the example that I like the best is the three little pigs. Here on the left we have a house being built of bricks, one in the middle made out of straw, and the house on the right made out of wood. Here we have the wolf. Well, which one is he going to not be able to get through? Well, it's a house made of bricks. So that's an expected result. But what you can tell your clients is that if the results are unexpected, surprisingly good, then a change in materials or a change in composition or a different assembly of known components could be considered unobvious and hence patentable. Because that's what the patent office is looking for, things that aren't obvious to bring to light to help the advancement of the sciences. A good example of unobviousness and a use patent is the patent on aspirin. The original one expired over 100 years ago. About 10-15 years ago, doctors found out, and it doesn't matter how they found out, whether by accident, experimentation, the patent office doesn't care how you find something out or how you invent something. It's not even discussed in the patent. In any event, these doctors figured out that if they give patients aspirin, that the incidence of heart attack and the severity of the heart attack are going to go down. And sure enough, they obtained a use patent for using aspirin to treat heart attacks. And now we all know that's the case, and now it may seem obvious, but 10-15 years ago that wasn't so obvious. So again, here is a known component with an unexpected result. That's one of my favorite examples of using things of known components, because most of your clients are going to come in, they're going to have known components. You go to Home Depot, you go to an electronics store, there aren't a lot of new components out there, but there are infinite ways to assemble them. So this comes up all the time, the assembly of known components. The best way to show something is unobvious is if the prior art teaches away from the invention. So this doesn't happen very often. But if you're lucky enough to find some books saying, if you go in and you go into a poisonous vat or a radioactive vat of material, bad things are going to happen to you. So here I'm showing somebody an asbestos suit, I'm showing some poison. But what if you had a client who figured out somehow that taking some really toxic chemicals achieved a desirable result? That'd be a great example of something that's unobvious, and they could show that the prior art or books or literature taught away from doing that. That's, again, just the gold standard for finding unobviousness. Another thing that comes up, clients will come in and, as the graphics show, they'll have these thoughts. Buying low, selling high, some business method, doing arbitrage of different rates of currency exchange. You'll hear everything about different schemes, almost maybe business methods that we'll talk about later. And here we show somebody just thinking. A pure idea or mental process is not patentable. It's also not protectable under copyright, trademark, or anything else. Just a pure thought, not reduced to writing, not reduced to a machine, or just a pure idea is not protectable. My favorite is people think about, well, what if I have this idea that I'll have a daycare center for dogs? Can I protect that? Can I patent that? And that the simple idea of that is just not protectable. Your best bet there is just to go do it if it's a good idea and to see what happens. Maybe you can patent things you discover along the way, problems you didn't anticipate in your doggy daycare center. Maybe how the dogs are checked in, how they're cleaned, things the client hasn't even thought of before. That's what I tell clients, go figure it out. If you solve some problems you didn't think of before, maybe that's where your patent's going to be. The new trend here with something called the Blitzky case is that 10, 15, maybe even 5 years ago, people would file these internet-based patents where you'd have the typical server, a user, and you'd be doing things, exchanging debits or credits, an eBay site. And the current trend, at least in the lower courts now, is that a pure computing invention without a specialized computer that does business methods, figure out the price of a stock at a certain time, doing currency exchange, that's not going to be patentable, because in the patent statute, the original one being in the Constitution, requires a change in matter or physical matter needs to be changed. So the best examples are a new composition of chemicals, a machine, a device. So that's why I've written down here that there's a perilous future for business patents that were so popular a few years ago. The most famous business patent was for a case called State Street Bank. And what that patent covered was to figure out the value of a share of a mutual fund at any particular time. And the court upheld that patent as a legitimate patent because it did something unobvious. And so currently with Blitzky, sort of a similar case involving the value of certain securities, the lower court said no. So we have a conflict between Blitzky and the State Street Bank case. The U.S. Supreme Court heard the Blitzky case 6 weeks ago from this taping, and the transcript of the arguments are available online. And in the next few months we'll find out whether we're going to have that physical matter component needed to obtain patents. For most clients it doesn't matter, because most clients come in, they're machinists and they have physical gadgets, a better way to do something. So that's not going to affect it, but it affects the what I call the Silicon Valley crowd who work for Google or some other great company, and they have some new way to manipulate information and they want to get a patent on it, and now it's more difficult to do so. So gadgets, mechanical devices have a good chance of becoming into a patent or being patentable, or having the application allowed to patent or allowed as a patent. That's sort of the nomenclature that you'll hear if you get to interact with any patent attorneys when you send your clients there to actually write the patent application. Electrical circuits are still very popular and very patentable. There's a lot of great circuits for involving cell phones, cell phone handsets that take your broadband, these big waves through the air, and put them into a smaller baseband, a smaller frequency that goes into the cell phone handset. So there's a lot of different ways to do that, and you see a lot of good patents in that field. Another thing is that a patent or a patentable invention doesn't have to be breathtaking. It doesn't have to, you don't have to have the first flying machine like the Wright brothers. You don't have to have the first light bulb like Thomas Edison. You can have a very small and perhaps mundane incremental improvement to an existing product or to an existing piece of machinery. And the best example of this, I find, comes from Mercedes-Benz, also known as Daimler-Benz. They run commercials from time to time that talk about their 10,000 patents. When they try to sell their cars, they sell a few. They talk about, buy our cars, we have 10,000 patents, we're the first to patent the airbags, and they talk about their 10,000 patents. Well, if you study their patents, you'll see that they're from very small incremental improvements, and that, in fact, there could be room for other patents in the art. And here's one that came out December 2008, just about a little less than a year ago. It's from a local inventor here in Marin County, California, a guy named Mr. Jones, and he invented a cylinder combustion system with a piston and a cylinder, an empty cylinder, and sort of a gizmo on the side, for lack of a better term, a turbine that spins. And the idea here is that the piston goes up and down through normal combustion where you have gas exploding, moving the piston back and forth, but there's no piston rod on this. And interestingly, there's other pistons systems that don't have rods either, and they go back, in fact, to 1875. And if you look at the screen there, there's one by Daimler of Daimler-Benz, Mercedes-Benz, and this is one that he didn't get every nuance to it. So a local inventor here in 2008 figures out some new twist. He comes in, and sure enough, we're able to get him a patent on this piston and cylinder. But we had to deal with and consider the prior art, in this case going back to 1875, in a very famous automaker. That's another issue that comes up when people come in about an invention. We have to figure out, is there prior art that's already disclosed this, and if so, they're not going to get a patent for it, or is there prior art, such as one in 1875, how can we phrase this differently or claim different things that aren't obvious from the prior art? Non-complex items are okay. It doesn't have to be as, the cylinder isn't that complicated, but there's even simpler items that are patentable. Here's one that we recently did for a guy named Mr. Goldberg. It's a wine badge identification system, and what it is, you can look up the patent online if you wish. It's a system of labeling wine bottles. So you can have these interchangeable tabs, so you don't have to mark the wine bottle up, and so you can have the tab at the back of the bottle or the front of the bottle, so when you stack these things normally, you can always see what the wine is, so you can impress your friends with your wine collection, and you don't have to handle the wine every time you want to see what type of wine you have. So this was issued November 17th, 2009, exactly a month ago. So this is a good example of what's patentable today. So as you can see, it's fairly simple technology, but again, this obtained a patent, and it's a great invention. I think it's very useful. He's selling lots of these things. So you never know, one, what's going to sell and what's going to become a patent. The other thing that I never do is give any suggestion, any opinion as to the marketability or profitability of a product. If I could call such things, I wouldn't be sitting here. I'd be retired. I would have bought Microsoft at $10 a share 25 years ago. I can't do it. There's just no way to figure out what's going to sell. So I have, even in my fee agreements, I state that I express no opinion as to the marketability of a project. You don't want clients coming back and say, well, you said this would sell, you said a patent would obtain, in my fee agreements, no promises are made that you're going to get a patent or that anything's going to happen at all, other than the patent will be filed. One thing you can guarantee clients when they file for a patent, at least a non-provisional patent, you can opt to have that patent published 18 months after your priority date. And I guarantee immortality with each non-provisional patent application, because that published application is going to be held on the USPTO servers and other internet servers forever. And so if your client's name's on that, his kids and grandkids are always going to see that. And that has some appeal to a client. And also it can act as a patent shield, so that if a client discloses things and opts to have the application published, and even if they don't get the patent, then they sort of burn the bridge behind them. Then a competitor, if they try to get a patent on it, that published patent application will be used against the competitor as prior art, and your client isn't going to be sued for patent infringement for his own product. So there's a defensive use to filing for patents that needs to be considered. And what's great in our country, these things are published, and it's out there for the world to see, and it burns the bridge for competitors to obtain their own patent and stop your client from making what arguably he invented, or at least what he's currently selling and what he's invested to sell. Another thing, there are no international patents, but there is a process called the PCT, which stands for Patent Cooperation Treaty. And pretty much every country in the world, every civilized country, is a member of the Patent Cooperation Treaty. And what that does, it doesn't give an international patent, but it prolongs the time, gives the client more time to file patent applications in each country. So this is a good example, this ball machine patent here we did, in that someone from Australia filed a PCT application, and then they called us up and said, you know, this is due in about 5 days. Can you file this in the US? And turned out everything was done correctly on this PCT application. So then we filed a national stage application in this country. So we were able to get the priority date of the original patent filed in Australia, and we filed the thing in this country. And of course some Australian lawyer did it, so we had to change the claims, kind of do some rehab, some Photoshop on the pictures or drawings to make them more acceptable to our standards. This country has the toughest standards for drawings, so when things come in from other countries, you have to often get them redrawn, or at least have somebody good with Photoshop to darken the lines and comply with the rules that are about this thick for the drawings. So on this PCT from Australia, it involved a pretty interesting piece of technology, a gun for throwing baseballs with a curve and adjustable curves. And you can go read about this patent. It's pretty interesting. What it has is different holders that spin and turn. And so this patent deals with how things are rotated, how you control that rotation to throw different, or to project various curveballs going. And this is by Hitting Labs in Australia. They sell a lot of these machines. And it's a very interesting piece of technology. What's also interesting is there's a second application that looks just like this, that's been allowed as a patent, hasn't come out yet, so I can't show it to you. But I'm sure it'll be on my website when it comes out. And it looks pretty much identical to this patent. The difference is the second patent to come out, the claims dealt with the barrel. Different holes in the barrel, different patterns of holes, and the first office action rejected all of the claims. So what we had to do, we had to go back and talk about unexpected results, and we had to look at the prior art used by the patent office that they used to combine features to assemble what the client had, this barrel with various holes. So what we did in the office action is we talked about how if you did assemble a gadget like this, that the underlying items wouldn't work, that it'd be inoperable. In other words, not foreseeable So if anybody's interested, I could send them the first office action where none of the claims were approved, and we got all the claims approved by showing that the combination of prior art used by the Patent Office simply wouldn't have worked. Okay. Some inventions deal with sporting equipment, and again, maybe aren't so complicated, but maybe the challenges faced to make the thing work are where the patent lies. Here we have someone in Marin County invented this golf swing guide. It's by Fig Jam, and they sell a lot of these things. There's a big golf market, and we have a lot of golf-related patents, including design patents for golf wallets. So what this one dealt with, it's a sort of a triangular piece that's assembled, and the golfer looks at it, swings, and if the club hits the piece, your brain hates it because you spend a lot of money on these clubs. The feel of driving your club into a piece of plastic just isn't good. So you practice and you get your fine motor skills going so that as you hit the ball, you have a sweeping stroke. So what was difficult in this project for the inventor, it wasn't the triangle system, it was to get the hinges to work. Because you find if the thing gets beat on, you don't want the hinges to break. It has to have different positions, it has to be economically made, and you have, to mass produce, you have these wonderful challenges in injection molding. Your clients will come to you and they'll get something made and they'll just always be crying about the injection molding process, how they spent $50,000 to have the mold made in China, and then they find out there's a night run in China where they're using their old molds to make knockoffs that are sold other places besides this country. So I'm just full of injection mold stories, and you'll hear them all the time as people get things. Manufacturers, you kind of have to pretend to kind of be surprised by it, but you can tell them this happens all the time. So the art in this invention is in the hinge work and how it was made. It's a great product, very strong, economical to make, and that's where the patent is. If you look at the claims, it's about the hinge work and the challenges the client had to overcome to make this work. And also, you have a lot of different utility with this application, this golf guide. It goes in different configurations for sand traps, different lies, different angles, and also you can set it up to draw and to fade. And these golf clients just go on and on about their products and what they do. It's pretty interesting, and also there's a lot of money in these golf inventions. Another great field for patents are the design patents. I think I showed this before. This is the hair clip. This is done. This is in South Africa by, I think it's Butterfly Magic, and they filed locally in South Africa. And then you get the phone call. This is due in I think 4 days. This was due. So I said, sure, I'll do it. And I used the drawings used in South Africa. Of course, we ended up having to redo all the drawings because in South Africa they don't really require very stringent drawings for their design patents. But we pushed it through, and now we're doing a fair number of different design patents on these hair clips. And so what's interesting when you look at the design patent, things that are not claimed or not original are drawn in dotted lines, and the industrial design that is original is drawn in solid lines. So when you study these various hair clip patents, you'll see various different designs in the beadwork. So they're pretty much infinite combinations, but this one client, they sell a lot of these all over the world, and people do knock them off. They copy the exact bead pattern. So with a design patent in this country, we can go there and shut them down, sue them for infringement, and make sure the client doesn't have their good brand diluted by knockoffs using the same pattern. When I first saw this, I thought, well, there's not much to this. Who would buy this? But it turns out a lot are sold, and it just goes to know that I have no idea what's going to sell, and I don't try to figure it out. And I suggest you would do the same, because who am I to squash someone's dreams as to what's going to sell? Okay, so here's the hair clip. That's actually a different one, and you'll see ZA. That stands for South Africa for some reason. Can anyone in this filled room tell me why South Africa, the initial is ZA? No one. something like that. Yeah, very good, very good. We have one. It could be. So anyway, when you do these, or when you deal with these different countries, they have a country code, and you figure it out, and you become quite good at it. But as you'll see here, I don't know if you can see from the video here, but the combs are dotted. That's not claimed, but it's this unique bead design that's claimed, and that's where the patents are. Other interesting design patent kind of piggybacks off the famous Las Vegas logo. Here's one. Here's a design patent for a CD holder by someone in San Francisco, and the idea here is you go to Las Vegas, you have some fun within reason, and you can buy a CD that has pictures of all these great sites that maybe you didn't really have time to go see. And so then you can buy it in this case, this metal case here. It says Las Vegas. And so we have sort of an interesting design to make this work, to hold the CDs, but also what's artistic and what's original to the inventor. So this is the patent. And so for a design patent, they're pretty obtainable. And this guy sells a lot of these things in Las Vegas, and he has them for other areas of the world where people might travel, do things, not want to take formal pictures of all the current sites, and they want to have some packaging. So packaging, artful packaging, can make for a very good design patent. Okay. Off the golf course. Another object of great design patents, where you're looking for the industrial design, the artfulness of it, and not the utility, but the fancifulness of it in a useful article. Underwear, women's underwear. I never thought that years of college, years of law school, sitting for the patent bar for I don't know how many days, studying books as far. Clients come in, they have some underwear. And so now I don't smirk, and sure enough, you get the patents for the underwear, and they sell quite well. Here's one. I'll just show the picture. Anyway, this is from a patent for underwear, and it's a design. There's artfulness to it, and for off the golf course, there you go. So you just never know what's going to be patentable and what's going to sell well. And there's actually two different types of underwear from this client, but I'm only going to burden you with one here. So to figure out what's patentable in 2010, there's still quite a bit left to patent, and probably the first step an inventor might want to take, you can either hire a patent lawyer for this, or there's search sites, or he can do a little bit on his own, is to figure out, is there any writing in any language anywhere in the world that discloses his or her invention. So I'll say it again. You see the graphic there. There's a glass on the entire world. There's a picture of a computer looking at the entire world. The only rule here is when a writing would not be used to preempt a patent or patent application is if it isn't indexed. So the extreme example is, say you're in Germany, and in German there's a library there, and somebody did their doctorate thesis on some radio wave technology or something like that. Who knows what it is? If there's an index card that identifies that writing, it can be used as prior art against your inventor. It's hard to come up with. Usually that sort of prior art comes up in litigation when people might try to invalidate a patent. So really the sky's the limit on previous writings, any language, anywhere in the world, as long as there's an index or some way to find it. It can be a paper index, like in grade school where you'd have little 3x5 cards. So you dig through there. So in a way, a search can go on forever. When a search is performed, there's no guarantee that all the prior art's going to be found. In fact, there's a guarantee that about 18 months is going to be missed. Because remember, we talked about how patent applications are published 18 months after the priority date. So if you were to hire me to do a search today, I could do a search. I'd find all the published patent applications, But say something was filed yesterday, I'm not going to see that in my search, and it may just preempt the inventor's invention in toto. But this prior art isn't going to come up till 18 months from now. So in my fee agreements for searches, I point out that there's that 18-month time, sort of called a submarine time, where prior art can pop up. And that's just a fact of life. It's just a risk the inventor assumes when they go ahead and file for their patent application, that it's just impossible to find all the prior art, and by necessity, 18 months is always going to be dark. And then people ask, well, when the patent application is reviewed by the patent office, are they going to go to Germany and go through the indexes and see the master's and doctorate dissertations? The answer is no. Typically, the patent office will look for published patents. Well, all patents are published patent applications, and some examiners are pretty diligent, and they'll find learned articles from textbooks on things, but it's pretty much in the realm of what's reasonable to find. But again, when you go into litigation, a patent can be invalidated in litigation, and then the sky's the limit. There are search companies that will go to Germany, look through the indexes, and try to find that prior art that'll invalidate a patent. Okay, so here, this is sort of a more important part of the talk here, are the deadlines. More lawyers are sued for missing deadlines than any other thing. It's one of the few things juries can understand. Did you miss a deadline? People really have no idea what I do in my office, but they would know if I missed a deadline. It'd just be really simple to find out you missed a deadline. There's a large international law firm a couple of years ago, had some filing, calendaring for a patent in a different country. A file clerk somehow accidentally, we hope, removed the date from the database. The date passed, and this big law firm got sued for malpractice, missing a date, and now the malpractice insurance for all IP lawyers has gone up significantly because of this one big case by this large law firm. So the importance of deadlines cannot be overemphasized. As a non-patent lawyer, probably won't be your job to calendar these dates, but it's a good idea to be able to tell the client so they don't lose rights figuring out whether they want to go see a patent lawyer or not to pursue their patent. So here are the big dates. An invention made or used in public or offered for sale, there's a 1-year time period to go file for patent protection. It's real easy. It's called the 1-year bar on sale. I have a picture of a 1-year-old baby here in a diaper with a time bomb. So 1-year-old, the thing blows up, no one's happy. So tell your clients that they have 1 year from their first offer of sale or their first public disclosure to go file for a patent application. And that's pretty much the rule everywhere in the world, the 1-year rule. Then the client has a decision whether to file provisional or non-provisional within the first year. We'll talk about the differences there. So that's the important U.S. deadline. Then we have the worldwide deadline, and fortunately, it's again sort of a 1-year deadline, in that the deadline to file for a patent application pretty much in the world is 1 year. In this country, clients typically don't want to spend all the money within a year to file in each individual country or to file an EPO, European Patent Application process. We're not going to have time to talk about, but that's another rubric to prolong the agony of having to spend money before you drop down in each country to get a patent in each country. So again, it's a 1-year rule with the PCT, Patent Cooperation Treaty. So typically what happens is people will file a provisional patent application because it's less expensive. It's about 1/4 the cost of a non-provisional. And then the 1 year will approach, and they'll remember, gee, I need to file a non-provisional within the 1 year, but they also need to know that they also have to file the Patent Cooperation Treaty application within the 1 year as well, or they won't fall into the protection of the PCT to be able to extend the time to spend more money to file more applications in more countries. So those are really the important deadlines. I'll go through them again. 1 year from sale or public disclosure, you need to file either a patent application, provisional, non-provisional, doesn't matter, and then 1 year from that first use or public sale, you need to file a PCT application. It's that simple. So you can tell clients you have 1 year from when you first show it or offer it to sell. Get some help before that year's up, and then I would follow up with a letter in writing or an email confirmed, telling them this 1 year rule so that they can't later say, well, gee, you didn't tell me about that. Give me the millions of dollars I would have made with my doggy catcher or whatever they have, or the dog stick thrower that turns out to be a big seller. So again, 1 year, go file something. Start filing things within 1 year. Go see a patent, send them to a patent attorney, and let them bear the weight of dealing with the 1 year rule. Now, here's what's more interesting to you is a lot of people have great practices and they want to move into the world of patent work. Patents are very popular. There's been a great increase in patent filings, and there's a lot of lawyers want to do patent work. Okay, what can you do? As a non-patent lawyer, as a regular licensed attorney, you have the ability and right to engage yourself in patent litigation. It's a wonderful world. I don't have time to talk about the whole rubric of it, how it works, but just in brief summary, you don't have to be a registered patent attorney to do patent litigation. You don't have to be an expert in any particular field. It's sort of like doing construction defect litigation, where you can hire experts to teach you the knowledge that you need to have so that you can explain complicated things to 12 jurors who weren't quite savvy enough to get out of jury duty. The other great thing about patent litigation that I personally enjoy is that the world of patents is so convoluted that most federal district courts have local patent rules. And it's a book, it's about, I don't know, 20, 30 pages, and it gives you a timeline and a rule book for all the special things that are going to happen in a patent litigation. You're going to have a Markman hearing to define words. You're going to have claim construction hearing again. You're going to have a tutorial where the inventor comes up and shows the judge how the technology works. You have all these special events that are unique to a patent case. But the beauty of it is it's a cookbook. You follow the rules. You better follow the rules, because these judges, these federal judges, they're appointed for life. They'll do bad things to you and your firm if you don't pay attention. You follow the rules, meet the deadlines, and you can do this. Patent litigation can be very rewarding. It's interesting, and you'll learn a lot, and it's a great introduction to the federal court system. When you start practicing in federal court, you won't want to go to state court again, because to me the rules are so concise in federal court that it's a very it's a good practice to have. Okay. Another area of work that a non-patent attorney can do with great competence is the work in patent license agreements. They're animals of contract, and there's a bit of learning to be done on learning about what's a re-examination, notice of re-examination, how patents have become invalidated in litigation. I think I will talk about that just briefly. That when someone sues for patent infringement, say you have a client with a patent, they find an infringer, they go sue them for infringement. The defendant was going to allege that, one, they don't infringe, and if they do infringe, this patent is invalid, and the whole validity of the patent can be retried in litigation. There's a presumption of validity that you walk into in court, but as we mentioned before, the defendant can go to Germany, go to Switzerland, anywhere in the world, look for some index information, published, very small publication, just these doctorate dissertations where maybe there's just one copy of it there, bring it into court and say, we saw this design before, or we saw this gadget or this concept before, and your patent's invalid. So clients have to understand, when you go sue, you put your patent at risk. You're all in. And so it adds to the stress level to patent litigation. On the other hand, if you're not willing to sue for a patent, what good is it? But as a non-patent attorney, maybe you want to do some patent litigation, you have to understand that you get to re-examine the patent, and that's when you'll learn about office actions and the whole procedure of how a patent starts as an application and then becomes allowed as a patent, and you relive that in the litigation. Sometimes usually the inventors are, their depots taken, sometimes the examiners are brought in, they don't remember anything. So you get to relive that agony or joy. Improving the patent. What's good though is most patent suits, they do settle before they even go to trial. They can be quite expensive, and usually people can work out some reasonable settlement, often involving a license agreement, maybe a cross-license agreement if you have two parties with competing technologies. And there's a lot of great patent license agreements that are written by non-patent attorneys. So that's a great area to get into. There's some great books on the subject. You can read them, digest them, and you can do patent license agreements and sub-license agreements. Now here's what you can't do. You can't bill for it, you can't get paid for it. The patent office isn't going to take certain work from you unless you're a registered patent attorney. And if you're registered, you'll know it. To become registered, one has to have a science degree from certain accredited universities, and then the different degrees have to have so many minimum units of certain types of sciences. It's quite an interesting maze to be admitted to the patent bar. So you definitely know if you're admitted or not. It's quite a rubric, and then you have an exam where you have to sort of be able to spit out or look up rules from a rule book that's about this thick. But it's doable if you have an interest in the minutia of it. So here's what you can't do, and you probably don't have an interest in doing anyway, is you're not allowed to charge people to draft or file a U.S. patent application. You can draft and file one for yourself. Your clients can go in pro per and draft and file one for themselves. But the patent office, if you go to their website, they really discourage that. You know, arguably, they discourage it by not making any sort of forms available for a patent. You go to the website, there are 50, 60 forms. There's not one form for an actual patent application. Kind of gives you a hint they don't want novices there jamming the system up with convoluted patent applications. It's kind of a good hint. Also, the practice of drafting patent applications, doing office actions, representing clients in the patent section of the United States Patent and Trademark Office, it's the only practice that requires a separate license, a separate exam, a separate type of education. One can do bankruptcy, divorces, securities, everything else. The only place you need a separate license is to do patent applications. It kind of tells you it's convoluted, it's wonderfully complex. So if you tell clients that, they kind of understand that it's difficult for them to do themselves. And fortunately, the patent office, they're going to spare you the embarrassment or the indignity of trying to figure it out, and you just say you can't do it. You send them off, they do it themselves, they find a patent practitioner to draft their application. The same goes with a patent cooperation treaty application. General attorney isn't allowed to draft it, isn't allowed to file it. It's just not your problem. You don't have to actually write these applications. The other thing you can't do, as we mentioned, represent others before the Patent and Trademark Office on the patent side. So if a client comes in, say they've done their own patent application, where they hired a patent attorney to do the application, and there's a falling out, and then the office action comes in, it says why this patent isn't going to issue. This is all obvious. Here's some prior art we found. You aren't allowed to file papers to refute those arguments. But you can find a patent lawyer to do it, and it works out better because they have sort of the rote answers to these sort of rote objections that we're seeing. And often an office action will require rewriting the claims, and one could study claim writing for years and years. And so it's not something that you have to do, and you don't want to do it. So it's easy to remember. You can do patent licenses, patent litigation. You just can't write patent applications. Now with the U.S. Patent and Trademark Office, you are allowed to pursue trademarks. So there's a dichotomy there. A normal lawyer can file trademarks. You can file copyrights with a copyright office. So it's just the patent punishment you aren't allowed to hurt yourself with.
The Center for Continuing Education, CCE, is a State Bar of California MCLE approved provider. CCE certifies that this program is approved for 1 hour of MCLE credit. CCE, the Center for Continuing Education, 395 Del Monte Center, Suite 178, Monterey, California, 93940. www.cce-mcle.com